protecting your business identity through trademarks, and the emphasis is on how to use marks to prevent competitors from taking advantage of your reputation. Now, it's an interesting topic because everyone sees trademarks all the time, but maybe you haven't thought through exactly what's going on in your mind. So we're going to look at a little bit of why trademarks are valuable, and then most importantly, we're going to go through from a legal perspective of how you'd protect them. Now, in order to talk about how we protect trademarks, we're going to look at things that have gone wrong in the past. So normally, in the vast majority of cases, if someone is upset with the trademark you're using, they will write some kind of cease and desist letter, and you'll work with them, maybe with lawyers, but hopefully not in front of a judge, hopefully not in court, to come to some resolution. But all of the examples that I have here are going to be things that went really wrong, and it actually went to court, and that's how we can have some discussion about how the courts decide. But so keep in mind that most of the time when people act reasonably, we can shortcut a lot of this down to just the principles and find some resolution that maybe works for everybody better than what a judge might impose. So if I'd say the word Coke, what comes to mind?
Coca-Cola.
All right. So when I said Coke, something like Coca-Cola, Diet Coke comes to mind. You probably weren't thinking about a fuel that's made from heating coal. So the ordinary English word Coke is a product that's made from taking coal and baking it. So how about roots? Clothing. So when an ordinary person just brings up roots in a conversation, you start thinking about the clothing company more than the part of a plant that attaches the plant to the ground. So these words have something more than their usual meaning. Polo, same idea. You start thinking about clothing again. And not so much about a strange game that you play on a horse, even though that's the logo. You start thinking about the clothing more than the game. And the last one here, if I say Monopoly, anybody? The game. Kind of slip through. But again, you're not thinking about the exclusive control of the supply of a commodity. You're thinking about a game. Now, these are ordinary words that now have a secondary meaning. They mean something different in the ordinary person's mind. Now, these are famous ones, but it applies to any trademark. So Monopoly, this is an interesting one because the exclusive control of a supply or commodity is exactly what we're talking about with trademarks. The control over the meaning associated with a word or phrase or an image. So let's go back. Does anybody else, any other companies, use the name Coke? Hope not. I'm sure that Coke would work hard to stop that. Same for Roots, same for Polo, and same for the game Monopoly. These companies are going to work hard to protect their monopoly over these names. Here's an ivory bar of soap from a very long time ago. And over the years, the packaging has changed. Sometime later, it changed again and again. So this, I believe, is the latest packaging for ivory. But it's still called ivory. So if someone talks about ivory soap, you can have an idea of what that soap is. If you can read, the label says that it floats, it's 99.44% pure. You have an idea of this white rectangular bar of soap. Now, more than just simply being soap, you've got an idea in your head of the soap that you used in the past, an expectation that if you buy ivory today, it's coming from the same source as that bar of soap that you bought 5, 10, 50 years ago. Now, hopefully, that also gives you some indication of the quality that you're expecting. So the trademark creates this association that relates also to the quality of the wares because you're trusting that source to keep giving you a consistent product. Let's take ivory a step further. If we go from bars of soap to dish soap, do you have an assumption from seeing this label that's made by the same company? Anybody? Yeah. And that's a part of the benefit of trademarks is now, even though the product is a slightly different one, this is ivory dishwashing soap instead of ivory bar soap, we still have a presumption in our minds that this is coming from the same source. And so even if we've never used ivory dishwashing soap, if we've used ivory bar soap, we're going to have some presumption that the quality of ivory bar soap is going to carry over to this new product. In this way, ivory has taken on a secondary meaning. So it was the name of elephant tusks, and now we had it associated with bars of soap. And now they've evolved, and it's taken on an even more generic meaning of, I suppose, cleaning products. But this is from a case that we're going to talk about a few times through the presentation. In green here is what the court describes as of the purpose of trademarks. Now, generally we talk about trademarks in terms of intellectual property. And broadly we can call that patents, copyright, and trademarks. There's a bunch of other categories as well, but those are the big ones. Now, for a patent, you talk about protecting an invention. You've invested some amount of creative or intelligent work to create something new, and in return for investing your time and efforts, the law protects that for a period of time. So you've got a monopoly over that invention for some time until hopefully you can recover the value of your investment. Copyrights also give you a monopoly so that if you create a creative work, so a literary work, a drawing, music, it also gets protection for a period of time. And the reason for this is that both patents and copyrights give a public benefit. The world is better off if people invent new things. The world's better off if you write new works, create new art, and so on. So if we talk about trademarks creating that connection between a brand and a company, then it doesn't really fall in that same category. You're not investing the same creative process to develop a trademark. But trademarks do serve the public interest, going back to the ivory sense of giving some confidence that what you buy today is coming from the same source as what you bought yesterday or some time ago. So they are different, and they're not quite the same amount of investment to create them, but they're protected in the same way of the value to the public interest. That was a bit wordy and a little bit awkward, so here's another way of describing it from the Supreme Court of Canada. Really, I promise there's not too many slides like this. And the purpose of trademarks is to distinguish wares manufactured by one company from those that are produced by another. So lots of words, but that's really what it comes down to, is making it clear that a label that you see identifies the source of goods or services. Can anybody tell me who this is? Barbie. You just look at it and you know. Someone could name their child Barbara. It's not an issue at all. Someone named Barbara can go by Barbie. Not an issue at all. But if someone starts talking about a doll called Barbie, then Mattel, that makes Barbie dolls, is going to be pretty upset. Now, the reason for that is that in your mind, the name Barbie goes with this doll, not just a doll in general. So if you decide instead that you want to make a different toy and call it Barbie, perhaps you want to make a Barbie car, well, you're probably also having trouble there because the Barbie doll is also associated in our minds with accessory products that go with it. So even though Barbie is specific to this doll, a Barbie car probably is also a problem because it's going to be confusing that related to it. We're going to talk about confusion a lot more. But the idea that a Barbie car isn't a Barbie doll probably isn't far enough removed to let someone else use that name. So Coca-Cola is a name that everyone recognizes for a drink. Now, if a competitor started selling a drink and called it Coca-Cola, I'm sure that Coca-Cola company would be upset. And when you go to a restaurant and you ask for Coke or Coca-Cola, you expect that that's what comes in your glass. You may not see the bottle, but most people, or many people that drink a lot of pop, would be upset if it came back with Pepsi or some other brand being passed off as if it were Coke. This one here, anybody idea what this is? Lego, all right. Now, how did you know it's Lego? What is it about this bit of plastic that makes you think it's Lego?
The knobs on the top.
All right. So Lego is actually a very important issue in trademark law. Now, it started out that someone, quite a long time ago, figured out if they made molded plastic with these bumps and the right shape on the bottom, they'd fit together. And if you have lots of these, it's pretty fun, so they started selling them. Now, that is a creative way of making a new product that fits together. We call that an invention, so it's protected by patent. Patents have a time limit. So Lego had many years of success with their patent protecting them. So the patent protection gives a monopoly over manufacturing that. In this case, we're talking about Canada, but really anywhere. And when the patent expired, then they're stuck with the problem of how do we keep anybody else from competing with us? We want to keep selling them and not have competitors take our market. So Then they turned and said, well, you know, if I hold this block, I know that a plastic block with bumps means Lego, right? That's my trademark. No one can make a plastic block with bumps. And from a starting point, that seems right. But then if we look a little further and ask ourselves, could we make plastic blocks with bumps in a different pattern that would fit? There really is no other way to make a plastic block that would fit with an existing Lego block if it didn't have this pattern on top. So now Lego was trying to use the idea of a trademark of this shape in order to protect an invention, something that's purely functional. And the courts decided that no, that doesn't work. That if an aspect of your design is purely functional, that's not something that trademarks apply to. So even though in your mind the pattern of bumps probably creates an association with Lego, that's not going to be a valid trademark. Did I just blow your mind? Yeah, and the reason that this is an important case is because it went to the Supreme Court of Canada, where Kirkby, who owned Lego at the time, sued Ritvic Holdings, which made, I believe it was Duplo or Mega Blocks. So exactly the same idea, plastic blocks that fit together, and there really aren't other ways of making them, especially if you want to make something that fits together with a Lego block. A trademark must have some form of essentially a decorative element, some embellishment. So it started out by an artisan creating some wares, signing their name. So that's why it's a mark. So it's more than just something that's purely functional. And the other important lesson is that trademark law is complicated. There's an awful lot going on, and there's no way that we're going to cover anywhere near as much as you would need to really understand it today, but hopefully we can get you started. Jumping right into how do we protect a trademark? If we've started our business up, we've got a product and a logo and so on, and we want to protect our name or our slogans, and we decide that, okay, this is something I'm going to use as my trademark. I want people to recognize me when they see this mark. So there's two essential broad categories of trademarks. They can be registered or unregistered. And both are protected more or less equally, but the mechanism is very different. We're going to talk about unregistered marks first, and then we'll see that registered marks more or less gives a shortcut to enforcing the owner's rights for a registered mark. And one important difference between unregistered marks and registered marks is just simply geography. So if you have an unregistered mark, you build a reputation among people in a certain geographic area, where a registered mark is, because the federal statute applies across all of Canada. So registration can, in some cases, be an easy way to establish a national presence for your mark. If I've established my trademark and somebody else opens a business and starts selling something using something that's very similar to my mark, and I think that that's a problem, then what we call that is I would make a claim for passing off, claiming that they are passing off their product as if it were mine. And assuming that things go badly and we wind up in court, these are the three factors that courts look to determine whether or not I'd be successful in stopping them from using what I believe is my mark. The existence of goodwill. So at common law, you can't just choose a mark and suddenly declare that this is my mark, nobody else can use it. You have to use it for a while first, build that reputation, and then you can protect it. So the example goes back with the Barbie doll. So the name has established a reputation. If you hear Barbie when someone's talking about toys, even if they don't say doll, if you say Barbies, people automatically start thinking about this. So there's a reputation built up, and we call that reputation goodwill. And more formally, the courts have described it as your reputation that's attached to your goods or services in the mind of the public. So there's a few different things going on in there. Reputation is important, but mind of the public is kind of a fuzzy idea. So sometimes people will turn to surveys to establish whether people in the community recognize that mark or not. So advertising, a history of using the mark, all of these things go together to establish goodwill. Does anybody recognize this picture? Disneyland. And in particular, this part of Disneyland is called Fantasyland. It was opened in 1955 when Disneyland first opened. It's down in Anaheim. And when you go into Fantasyland, it's a place where you can take rides, you can meet Disney characters. And it's been pretty well established. People all over the world know Disneyland. Fantasyland may be less known, but people still recognize Disneyland. And going to this part of Disneyland with the characters that you can meet and the rides and so on. And then this is one of the theme rooms in the Fantasyland Hotel at West Edmonton Mall. So that seems kind of funny, right? There's a hotel in Edmonton named Fantasyland. What is going on? Why hasn't Disney shut them down, right? So there was actually a pretty major series of lawsuits. Disney tried to sue the developer of the hotel for about 15 years, quite a slow process. And in the end, in one of these decisions, in one decision, the court found that the amusement park, part of West Edmonton Mall, which they also called Fantasyland, was clearly taking advantage of the goodwill of Disney's Fantasyland amusement park. They're so similar, and they just had the same name. So that was a problem. But then the court had some trouble with the idea about a hotel using the same name. Is that actually taking advantage of the goodwill of the amusement park? And in this case, the court said no. People that were surveyed recognized the name Fantasyland in terms of an amusement park, of rides, of characters, but they didn't think hotels. So at the time, Disney did have a few hotels around the world, but they didn't call them Fantasyland. So there was a distinction between the value of Fantasyland with respect to amusement parks and Fantasyland being used for a hotel. So in the end, the hotel won out, and at West Edmonton Mall, there is a hotel called Fantasyland Hotel with theme rooms and so on. There's still an amusement park at West Edmonton Mall, but it's not called Fantasyland anymore. So the next step of establishing that someone's passed off on your mark is demonstrating that there has been some deception of the public from a misrepresentation. And the basic problem here is if someone has chosen a mark that's similar to yours, is it going to lead the public to believe that that product came from you? Remember, we're trying to create trademarks that associate people with us. So if someone else uses the same trademark, are they trying to confuse somebody else into believing that it was actually my product, but the money goes to this other person? Or are they truly trying to create their own product and their own brand? Barbie came out in, I don't have the date here, a very long time ago. She's a lot older than she looks. And then in 1992, somebody opened a chain of restaurants in Montreal. They called them Barbies. Now it also happened that Barbies offers barbecued hamburgers and steaks. It's a family restaurant. And in 1993, they decided they'd like to register this logo as their trademark. So Mattel opposed the application, claiming they were passing off. And this is where we start talking about, could someone really be confused? Does this make someone think about Barbie dolls, the sign on a restaurant? So I'm not sure why this went as far as it did, but it actually went to the Supreme Court of Canada. Barbie's restaurant opened in 1992. They tried to register their trademark in 1993. It took until 2006 for the Supreme Court of Canada to finally put an end to all this. So 13 years of litigation, I can't imagine how much it cost both sides. I'm not sure why they would do all this. But again, business people acting reasonably should never go this far. Fortunately, they did, because now we've got some more indication from the courts of what exactly this deception means. And the bottom line is, well, really the bottom line there, can you believe that a company that makes Barbie dolls has any kind of association with a restaurant that has this Barbie's logo? And I think that the court came to a pretty reasonable decision in saying that no, there's a distinction there, that you wouldn't be confused by seeing the Barbie's logo or the name into thinking that a Barbie doll is associated with it in some way, or Mattel is running the restaurant or something like that. So Barbie's restaurant is still operating around Montreal. They've got half a dozen restaurants and a really annoying set of commercials. And so the third part of this test is actual or potential damage to the plaintiff. Now, here we're talking about financial damage or reputational damage. The good news is that there's a presumption. If you've established that you have a reputation or goodwill in your trademark, and you've established that someone else is misrepresenting or causing some confusion in the marketplace by using a mark that's the same or similar, then there's a presumption that you've suffered some harm because of that. So it seems great. Like step 3, why is it even here? We've won. That's it. So here's an example where this third part comes up and is important. In the mid-90s, as everyone was getting excited about the internet and buying domain names and all that, this Canadian domain name exchange registered the domains lawsocietyofbc.ca and lsbc.ca. Now, the Law Society's actual website is lawsociety.bc.ca. And so the Law Society felt that an ordinary consumer, an ordinary citizen of our province, or a lawyer trying to find the Law Society's website might type those in, and in this case, they got forwarded to adult websites, or after that was shut down, then it went on to political advertising for a candidate for an election. So the court didn't have too much trouble in deciding that there was goodwill, that the Law Society's name was well known, that people associated the Law Society of BC with the actual Law Society of British Columbia. And they didn't have trouble finding that either of these names was confusing, that an ordinary member of the public might expect that either of those would take them to the Law Society's website. And so because the third factor there, that actual damages or potential damage is presumed, the Law Society wins. It's great. But the flip side is then the court needs to turn to what do we do next. So the court awarded an injunction that stopped the Canada Domain Name Corporation from using either of these websites. But when it came to how much money should they pay to the Law Society for any harm to cost the reputation, there really wasn't any evidence. The Law Society couldn't say that because these websites were operated for this many years, this many people were confused, so we need to get this many dollars to be made whole again. So the court looked at just similar examples of places of other decisions the courts had made about passing off, and ended up awarding, I think it was $4,000 to the Law Society. As far as I can tell, that's essentially an arbitrary number based on some other organizations' passing off claim, but the Law Society couldn't offer any evidence about how much a fair award would be. As a very quick tour, that is the three factors of the common law protection for passing off. So common law is judge-made law. It evolves over time, kind of step by step, as the different levels of court look at things. And now we'll look at the registered trademarks, which are created by legislation. And so registration makes protecting a trademark simpler than protecting an unregistered mark. And the reason for this, there's a few reasons, but the act of registering your mark establishes goodwill in the mark. So you can skip that first step. If you think someone is infringing by using your trademark or something similar, confusingly similar, you don't need to try and demonstrate to the court that it's your mark. You've registered it, you've proven already that it's yours. And in the event that someone exactly copies your trademark, you don't need to do anything to prove confusion. Your registered mark is yours and nobody else can use it. So if they've exactly copied, then you've also qualified that second step. And the third one is presumed, so things can progress fairly simply. And even if someone chooses a similar mark to your registered mark, the confusion step is the issues to deal with at court are simpler. But the flip side of it is now, if someone is defending a claim, if someone says that you've copied their registered mark, the first step that most lawyers would recommend is that you try and demonstrate to the court that their mark should never have been registered, that their mark was invalid or ineligible for being registered. So you open up a different type of defense for the other side. The good news is that the process of registering a mark is pretty rigorous. So by the time you get there, it's not incredibly common that someone can be successful in having your mark deregistered. But that still is the common defense. So something important to keep in mind is that registration does not actually change anything about the nature of trademarks. We're still talking about this goodwill between some name or mark and your wares that creates a connection between the mark and the source of the wares. But it just makes a more effective tool for protecting your rights around that mark. So to be a little more explicit about it, the legislation gives you an exclusive right across Canada to use that mark. So where in an unregistered mark, if you felt that someone in Nova Scotia was copying your logo, you would have to demonstrate that people in Nova Scotia have an issue with the people in Nova Scotia understand or recognize your logo there. With a registered trademark, you don't need to do that step. Everyone across Canada, everywhere across Canada, you have a right to use that mark. You don't need to demonstrate that people everywhere recognize it. The registration takes care of that for you. All right, so here is an example of a dispute over a registered trademark. So High Times magazine was registered in Canada in 1980. So they registered the name High Times in relation to a magazine, and they also used that name for selling various products related to marijuana. And in 2006, someone in Niagara Falls had the great idea of opening the High Times Smoke Shop and Gifts. And so High Times magazine, if you have a little look here, so the logo changes a few times, but most of the time it's fairly similar with these ones. If you look particularly at the G, it kind of comes to a point at the bottom, and the M has this angled shape to it. And then if we look at what High Times did, they copied that same idea of the G coming to a point, and the M has a very similar shape. If you look at the two logos side by side, they're remarkably similar. I don't think there could be a suggestion that that High Times was trying to do something different. They were really trying to take advantage of the fact that people recognize High Times around the magazine, and then they wanted to open a store that sells products related to the products listed in the magazine. So it was fairly straightforward for High Times to demonstrate to the court that they had a registered mark, that there was confusion, they're so similar. And then the interesting part of this one is that the operators of High Times Smoke Shop and Gifts just didn't participate. They let themselves get sued, they didn't do anything. So in the end, they had a default judgment against them. And so another takeaway here is if someone is threatening legal action, engage and be a part of it, because maybe there was some way that High Times Smoke Shop could have carried on business differently. So as a default judgment, they lost. High Times Magazine was able to stop them from using that name at all. But because they didn't participate, there was also the challenge of damages. So the court awarded the injunction to stop High Times Smoke Shop from using that name, but then how was the court going to assign some value back to the magazine? The magazine claimed that if someone wanted to use the logo on a smoke shop, they would have licensed it to them for a couple $100,000 a year, but they'd never done that before. So the court had to look at that and say, well, we have no idea if that's realistic or not. Would someone actually pay that? So in the end, the court simply decided on what a fair amount was for licensing and for damages to the reputation. I don't know the exact dollar amount, but in any event, even though they won, they didn't have to prove that third factor of the infringement claim. There still needs to be some mechanism for quantifying how much harm is done to your brand or how much actual economic loss you have because of that confusion when it comes to the end. If we look at what kinds of marks can be registered, it's fairly broad. But the legislation is very complex around what can be registered and what can't. But these are some of the more important points here. Obviously, you can't be confusing with a registered trademark. It doesn't make sense if Coca-Cola's gone to the trouble of registering the name Coca-Cola. It wouldn't make sense if I could register Coca-Cola with K's instead of C's. That would kind of defeat the purpose of registration. So when you go through the process of registering a mark, one of the first steps is that the clerks in the trademark office will look at it and say, well, is there something else that's similar? And if there's something that's obviously similar, they'll reject it. And then next, the mark is, your proposed trademark is put into the Trademarks Journal, so anybody across Canada or around the world can look and see who's trying to register what new marks, and that gives you an opportunity to object to the marks being registered. You also can't use the name for the actual product that you're trying to sell. So if I ran a aircraft manufacturer, I could not trademark Avion for making airplanes. That's just the name in French. Now, Avion is the name of an awards program done through Visa, and there's enough of a distinction between avion for travel generally, and it's not actually the name of the product of an airplane. So there's always distinctions. You need to understand what exactly you're labeling. There's a whole series of official marks that are prohibited, so you can't trademark Canada. You might be able to use Canada in a longer name, but generally you couldn't trademark Canada or Penticton or British Columbia. You also couldn't trademark something like RCMP or Royal Canadian Mounted Police. And recently, all of the Olympic logos were added as official marks as well, so you can't use the 5 rings or Vancouver 2010. Those kinds of things are also protected. And there's quite a long list of types of things that are prohibited in the Trademarks Act. So I think this is probably a good time to mention that if you're thinking about registering a trademark, then most likely you're going to want to work with a trademark agent. So trademark agents are, they're often lawyers, they're not always lawyers, but they're people that have studied trademark law for several years, and then they passed an exam. And those are the people that are recognized by the Trademarks Office as being allowed to register trademarks and represent you before them in any hearings. So I'm not a trademark agent, but I can help you figure out what kinds of marks would make sense for you. And in the same way that I'd send you to if I'm helping you figure out a tax issue, I'd send you to an accountant. At some point, if I'm helping with a trademark, I would send you to a trademark agent to do the actual registration. So lots of lawyers can help you with the general issues, and then there's only, as far as I know, 2 or 3 trademark agents in town that could do the registration for you.
But it's also possible to do that without an agent.
You can do it yourself, but then it's a question for you of what the value of your time is compared to the complexity of the job of registering it. So you're always welcome to do that on your own. My recommendation, I'm not a trademark agent, I'm not selling it, so I would still recommend people hire someone to get help. It's complicated enough that it needs to be done properly. And so, if you have registered mark, I think I mentioned this before, one of the most common defenses that someone's going to start with is just saying, hey, hold on, you can't stop me from using that mark because you shouldn't have had it registered in the first place. Now, it's a real, something that people really do. It's an obvious place to start, but it's generally not going to be effective. The Trademark Act is complicated enough to start with. The process of having clerks review it and then having it published in the Trademark Journal so that anybody else can oppose it before it's registered it's a pretty robust process. So generally, you're not going to be successful, but that is where you would face your first challenge if you're trying to stop someone from using your mark. An obvious place to start is have a trademark agent help you early on. So when you decide that you have some logo or name that you want to protect or that you want to use as a trademark, you can hire a trademark agent to do lots of searches for you. They'll check if anything's been registered. But you can also help yourself a lot with Google. So search for, if it's a name that you're using, search for the name and then any variations or like smaller parts that make sense. And to an extent, you can do all the due diligence, but there might be surprises of someone else using the mark that you're not aware of. But certainly if someone has a registered mark, you ought to be able to find that with doing a search of the registry. And if it's an unregistered mark, for them to be successful, they'd have to establish a reputation, so they should be findable. If they're confusingly similar to yours, then it ought to be possible for you to find them on Google or some other type of search.
Does that count worldwide or just within Canada or just within BC?
So trademarks are a federal matter, so registration applies federally, where the unregistered marks, even though it's still, I suppose you'd call it a federal law, there's more of an issue about the geographic area. So if only people around, like for your business, if only people in the Okanagan were aware of your business, it would be difficult for you to stop someone in, say, Quebec from starting another business with the same name with an unregistered mark. And that's one example where registration would really help you, of establishing that right to use the name across the country. One of the steps when you're registering your business is doing they call it a nuance search. And that looks at all of the business names, and it also does a search of the trademark registry. But it's an automated search, and it may or may not find someone that's got a registered mark that someone thinks is confusingly similar with what you're trying to use. So yes, it does do a search everywhere, but simply registering your business name is not the same as registering a trademark in that name. So
But it might be a starting point for
Yeah, it didn't catch it.
Yeah, and it's really effective only in the case where you've got identical marks, something that's similar. You really need someone, a human, to step in and do a search, both like internet searches as well as manually searching the registries. One of the most important ways to develop your goodwill is to simply use it, to be successful in selling your product to as many people in as many places as possible so that that reputation grows and grows, even if it's not a registered mark. Right. So I'll jump into a couple of more examples here. Toys R Us and Nuts R Us. So this one was an interesting case. So this was, it started in the, I think it was in the mid-'80s. So Toys R Us was still fairly small. Nuts R Us was just opening up. It was a husband and wife operation to just make and sell packaged nuts. At the time, Toys R Us obviously sold toys. They also sold like potato chips and candies and packaged nuts. Toys R Us even had packaged nuts with the Toys R Us logo on it. So Toys R Us thought, hey, we sell nuts. It's got our logo on it. Nuts R Us. That sounds like Toys R Us. You know, it's confusing. Someone might think that it's ours. So it should be just a no-brainer. We should be able to stop them. Toys R Us was wrong. So in this case, it was interesting that Nuts R Us was a husband and wife opening it up. The wife told the court that she didn't know about the name. The husband actually said that he had heard of Toys R Us and thought it was clever, using an R instead of ARE for the name. So they had copied that style of name. But in the end, the court looked at the fact that Toys R Us sold millions and millions of dollars of toys and thousands of dollars of nuts. They were a toy company. Their competitors in the marketplace were toy companies. They weren't competing against nut companies. It was just that they happened to sell some nuts as well. Where Nuts R Us was a nut company, not a toy company at all, and not trying to truly compete against Toys R Us, they just happened to like the logo and the cleverness of using that R Us name. So again, interestingly, they had to go to court over this. They couldn't work it out between themselves. So Toys R Us tried to demonstrate to the court goodwill and the goodwill in their name and their marks by using a survey. So they went to consumers, and in this case, they went to a mall in Montreal and asked 100 or 200 people. They went to another mall in Toronto and asked a couple of hundred people. And they asked them about things like, do you think that this Nuts R Us came from Toys R Us? And very few people actually made that connection. So a few people, about 10%, felt that Nuts R Us might have been made by Toys R Us. So there might have been an issue there. But the court said, well, hold on now. You asked a couple hundred people in one mall in Montreal, a couple hundred people in one mall in Toronto, and you think that's representative of people across Canada? You've only talked to mall shoppers. You've only talked to people on a certain day. We don't know how you chose those people. We don't have any control group to see how they'd answer other questions. We definitely don't have an idea of what rural Canadians think about either of the marks. So even at the point where they've done all their work, they've been fighting for years, they go to court, they think they've got proof that they've got goodwill. The court said, you know, you really didn't do your homework here. You don't have proof that people across the country recognize your mark well enough in the context of nuts. So in the end, there was this lack of goodwill established for the Toys R Us brand in nuts. And I think the most important part was that they're just very different categories of business. So there was no passing off found there. Has everybody heard of Popeye? So it's been a long time since the cartoons were on. And these days, people are trying to use the name of Popeye in a lot of different businesses. There's, in this case, it was Popeye's Sailor Exchange, which was basically a place where sailors could go and take their used products and sell them and get other people's used goods, like a flea market, essentially. And so this Hearst Holdings is the company that had the rights to the name Popeye in Canada. They're related to the company that produced the Popeye cartoons. And they didn't want Popeye Sailor Exchange using the name Popeye. They felt that that would harm the reputation of the cartoon character, or at least that they could get some money back from the Popeye Sailor Exchange in exchange for them using that mark. So in this case, I think it's a pretty important lesson here. One of the big factors for finding that there was no confusion in the marketplace was that the owners of the Popeye trademark had let at least 13 other businesses around Canada use the name without actually going after them for many years. So if Popeye Sailors Exchange was being sued, they were able to show that there was already 13 other companies using Popeye. Popeye itself wasn't unique enough. It didn't make people think about, in this case, Hearst Holdings enough that it was worth being protected anymore. So it's important for those of us in business that when we're creating our trademarks that we use them, but also that we diligently go after anyone that is trying to use something that's confusingly similar. If Hearst Holdings or whoever owned Popeye before them had gone after all these companies all along, they might have been more successful against Popeye Sailor Exchange. But in this case, because they'd waited so long and had let so many people get away with it, the court felt that it wasn't, their goodwill had been diluted so much that they didn't have a mark to protect anymore. So similarly, Pink Panther, it was a couple of movies in the 70s. And it was registered as a trademark in Canada related to films and movies. And at this point, in 1998, it had been registered for about 30 years. I guess the movie's from the 60s then. And in 1986, this company came along making hair products, and they figured they'd call their shampoos and conditioners Pink Panther. So the court looked at this and was like, well, you know, they're different. We're not talking about a movie, we're talking about hair products. Someone's not going to pick up a bottle of shampoo that says Pink Panther, and they're not going to think that it was made by the company that made these movies. Now, there's a little bit of play off there. They're taking advantage of the fact that everyone recognized the name Pink Panther, but there's not going to be the confusion that no one's going to think that Pink Panther shampoo came from the company that made the Pink Panther movies. So in that case, the court said that it was okay for Pink Panther to use that name for beauty products. But they made an important note in their decision highlighting the fact that if Pink Panther starts putting like references to Hollywood, or if they start putting like a film strip on their logo, on their packaging, then they're moving awfully close to trying to establish that there is some link between them and Hollywood. So the court said, yeah, you can use Pink Panther on shampoo, but you know, be aware, you're on a fine line here. If you do too much about highlighting this link with Hollywood, you're going to cross over that line and be confusing. So does anybody here know champagne? What is quality of champagne? Describe what champagne means to you. Anybody? Bubbles? Generally, you think of a fine wine, not a cheap wine, something that's got some quality behind it. So this is an interesting case. The plaintiff here, this long name that I'm not going to try and read badly in French, is the organization in France that controls the name Champagne for the region in France. And through treaties, they also have the right to use that name in Canada. So we can skip over that first part about establishing goodwill and reputation. They essentially, because of the treaty, have the right to use the name Champagne here. And so they were claiming that champagne had been made for a very long time, so about 1,600 years, and that people recognized the name Champagne as a product of good quality that came from a certain region in France. And along came these Canadian companies, Canadian wineries selling Canadian champagne. And they felt that this was a bad thing, that the marketplace would be confused and somehow think that Canadian champagne comes from France. So it's a bit of a stretch. They went to the marketplace with surveys, and they couldn't establish that Canadian champagne, the name of both words Canadian and champagne together, caused anybody to think that it was from France. So in that case, Canadian companies were able to use Canadian champagne to describe their product, even highlighting the fact that they were trying to benefit from the reputation of the quality and the style of champagnes from France. Using the name Canadian champagne was okay. So the plaintiff here did a telephone survey. They asked lots of people. So the survey was a lot better than that one we saw earlier with the Toys R Us. And they ask questions like, what, if anything, does the word champagne mean to you? They ask questions like, when you think of champagne, do you think of any particular countries? And then what countries do you think of? But they never actually got around to asking the question, what do you think of when you hear Canadian champagne? So they really didn't answer the important question here of, was Canadian champagne confusing with just simply champagne? So Andre's Wine actually admitted that they said that the reputation of French champagne is high and its quality premium, and that they benefit from such reputation by using the term champagne to describe their sparkling wine, Andre's, which is produced from the highest quality grapes and by the double fermentation process similar to that employed by the French champagne houses of France. So they were really open and honest about saying, we're really trying to copy champagne. But they said simply that there's no misrepresentation because clearly Canadian champagne doesn't come from France. So in the end, the court agreed with them that no, it's not copying champagne. They're being clear that there's something different, but saying that champagne is just simply descriptive of the process and the type of wine, not describing the source. So that, Andres was really making the argument that there wasn't that link between champagne and the source of the goods as much as this French organization was trying to argue. So just so we know what we're talking about here, if you can read the logo, it actually is Baby Canadian Champagne. This is from the BC liquor store's website, $6.29 for a 750 ml bottle. So it's a bit of a stretch for the plaintiff to be arguing that, that anyone could be confused that this is a high quality product. I'm sure Andres will tell you that it's made in the champagne style, but certainly between being Canadian specifically, it can't be more obviously Canadian champagne, and by being in a whole different class, by being at 629, it's pretty hard to argue that they're talking about the same thing, even though they are both talking about wine. And I'm sure you've seen the little R with a circle and the TM next to trademarks all over the place. Those are important in the States, but in Canada, they're not actually required by legislation. The Trademarks Act doesn't talk about either one. In the US, normally the R is used to say it's a registered trademark, and the TM is used on unregistered marks. So you're certainly welcome to use either one. There's nothing stopping you from doing that in Canada. Be careful if you're selling products in the States because they have meanings there. Using TM is a good way to tell the marketplace that some mark, some name, or some symbol is important to you as a trademark, so it's something that you intend to protect. It kind of gives a little heads up that if you copy my name, I'm going to do what I can to stop you. But beyond that, it doesn't really mean a lot. If you do turn around and want to register your mark, being able to show that you'd used the TM beside it for some time might be a useful way of demonstrating that you have a history of using that mark. But I've also got a counterexample where this is the label from some face cream, and the company that makes it wanted to register the name Aloe Vite. But the problem that the court had was that the TM is after all 4 words. I know it's a really horrible copy of it, but the court said that the TM was suggesting that this whole phrase was something they're trying to protect, not Aloe Vite. And so the court ended up saying that this is not evidence of using just Aloe Vite as a trademark, so that wasn't helpful for them. So if you do decide to use R or TM in your marks, be really careful. And again, this is something that a trademark agent might be a useful tool to help you understand where and how to identify which marks are meaningful to your business, and then also make sure that you use those properly. Probably the most important step when you're looking at protecting your brand identity is be really careful to make sure that you've got a brand that's unique. It's something that no one else is using to the best you can. Certainly, we wouldn't have all these examples if it was that easy. So there's easily hundreds or maybe thousands of lawsuits that involve people disagreeing over whether a mark is confusingly similar or whether goodwill is established and all that. And if there's that many judicial decisions, then there'd be 10 times as much or more of disagreements in the in the marketplace where people actually got together and worked it out and solved it themselves. So it really is common. It happens lots. So just do your best to search carefully before you adopt a certain mark. And a trademark agent is definitely a great investment if you compare a few $1,000s now to 10 or 13 years of litigation. So it's good to invest up front. And with that, once you've established your mark, once you've started using it for a while and you feel that it's offering some value, having people recognize some mark and build a goodwill relating the mark to your brand or to your company, consider registering it. It helps you short circuit that step of establishing a goodwill across the country. It helps you, if you are being challenged at any time, it helps you have that presumption that you have the right to use it everywhere. And it also gives you the opportunity to stop anybody that you find in another part of the country from using that mark. So it's, again, it can be an expensive process to get your mark done, but relative to the harm to your brand of having somebody else competing with the same name or the same trademark, or the cost of changing your business if you lose out and someone else is in the way, it could be really worthwhile registering your mark as early as it makes sense. And you need to defend your marks vigorously. So we saw the example of dilution where Popeyes let 13 or more companies use the mark. So even though it was a registered mark, they lost the ability to defend it because they simply hadn't defended it enough over the years. They couldn't come along after just letting things go for a long time and try and clean up everybody all at once. The court just wouldn't go there. So even being a registered mark, you need to make sure that you do what you can to prevent somebody else from encroaching on your goodwill. Which means the most important part is that you actually use your trademark. You need to get it out as much as you can. When you're advertising, make sure you use the same trademarks over and over so that association between your mark and your company is built up as much as possible. That makes good business sense, but it also helps protect you from a legal perspective.